It is April 24th of 2026, and this is the Court Gallery. Welcome, ladies and gentlemen. Today we are diving into a court compilation that is absolutely packed with drama and disbelief. First up, we're in Judge Ricke's courtroom, where he has to listen to a probation violator spin a wild tale involving guns, a flat tire on his motorhome, and even his cat. You really can't make this stuff up. But this is just the beginning, ladies and gentlemen. We'll also see a defendant who named his business something so unbelievable it leaves one judge completely speechless. And then get ready for some intense child support hearings with Judge Hesselink, who delivers one reality check after another to a bunch of deadbeats who can't get things together. The excuses are wild, the judges are fed up, and it all starts right now.
The District Court of Butler County, Kansas. The first case on this docket is State of Kansas versus Christy Rose Ginsburg. It's case number 2024 CR 353. Ms. Ginsburg appears at the detention facility Zoom location. Joseph Baca as prosecuting attorney. Joseph Favre as defense counsel. This matter comes before the court at this time for hearing in relation to a warrant to show cause alleging probation violation. I'm going to try to determine what violations are currently before the court.
I believe there's an original warrant and an addendum from Ms. Ginsburg.
You see that? Would appear failure to remain drug-free, a positive test for methamphetamine, failing to report for scheduled drug screens, failing to complete an alcohol and drug treatment program. And then the addendum would seem to address additional problems in the case. Okay, listed as a suspect for use of a financial card, failing to obtain permission before leaving the county. Defendant was at Gilley's Casino in December, which is an alcohol serving establishment. And then social contact with Mark Alfaro. And that's someone that was on court-ordered supervision, apparently. All right. What announcement is made regarding these allegations, Mr. Favre?
Judge, Ms. Ginsburg has reviewed them and will stipulate to the violations of both the original warrant to show cause as well as the addendum.
All right. Ms. Ginsburg, you've heard your attorney's announcement. Is it your intention to agree that you committed all these violations, which the court outlined earlier?
Yes, Your Honor.
And in doing so, you'd be waiving any due process hearing that you'd otherwise be entitled to, where the state would have the obligation of proving these allegations by a preponderance of the evidence. You can challenge the state's evidence, present your own, have the assistance of your lawyer, confront the state's witnesses unless good cause was shown. And I need to make sure you're aware that, among other lesser remedies, the court could consider just an outright revocation of your probation and having you serve the remaining balance of your sentence locked up. You understand these things?
Yes, Your Honor, I do.
And that apparently, at least on your primary count at sentencing, you received a 30-month Department of Corrections sentence. So you understand that that's a possible outcome here, that you serve that time.
Yes, Your Honor.
Okay. But you're waiving a hearing and stipulating and agreeing that you committed the violations which were outlined by the court on the record here.
Yes, Your Honor.
Very well. Court finds that this is a free and voluntary act on the defendant's part. He's waived a hearing and stipulated to violations, which are substantial and material violations of the terms and conditions of the defendant's probation. We'll turn to disposition in the case. Mr. Baca, what are you recommending here as an appropriate remedy for her violations?
Well, Your Honor, we've had a prior probation violation where she served a 72-hour sanction already, and we've reached the point we're still at today. I don't believe she's amenable to probation at this time. However, given a stipulation today, and I believe Mr. Favre is made aware, state would move and is willing to modify her original sentence down to 20 months, but then we'd ask the court to revoke probation and have her serve that modified 20 months if the court is agreeable.
All right. Thank you, Mr. Baca. Mr. Favre, your recommendations regarding an appropriate disposition.
Judge, that is an agreed upon disposition. Mr. Baca and I spoke, Ms. Ashenfelter and I spoke, and Ms. Ginsburg and I spoke, and I feel that Ms. Ginsburg has stated to me that she feels like she's had some successes on probation, but it overall has just not worked out. She's had a lot of dropping out of treatments, and Ms. Ashenfelter expressed to me that she has also feel like she's tried everything she can for Ms. Ginsburg. So we think that 20 months, based on her acceptance and based on the limited successes that she did have, though none of them lasted, is an appropriate sentence, and she's going to agree to go to DOC and serve that out.
All right. Ms. Ginsburg, you've heard the announcement of your attorney in conjunction with the recommendation of the prosecutor. Is there anything that you wish to state on your own in mitigation of punishment here?
Just a thought that I've also lost my son through this last year, so it's caused me some problems to get on track. That's all.
Ms. Ginsburg, obviously the court would express sympathy for any family loss that you've had in this last year. I don't make light of that at all. Grief is a powerful thing, but the reality is that one reason that you're ordered into treatment is so that as stresses in life come up, you're in a better position to handle them.
Yes, Your Honor.
If you're not going to actively participate in such a treatment program, things are never going to improve.
Yes, Your Honor.
It does appear to the court that your probation has been, I think in summary, a complete lack of success. It does appear to the court that it's appropriate to enter an order at this time outright revoking the probation of Christy Rose Ginsburg, as has been suggested here. The court will exercise its authority under KSA 2237-16 to downward modify the sentence to 20 months, as the parties have agreed. I think that's a sufficient prison sentence under these circumstances. You're to be given jail time credit for all time previously served, Ms. Ginsburg. There is a 12 months post-release supervision period, which the court reannounces, and 20% of good time credit, which I hope you earn every day of, Ms. Ginsburg, to earn your earliest possible release date. Obviously, in light of the court's incarceration sentence, no further amounts for bids-related services will be imposed. However, anything that was previously owed remains to be paid by this defendant, and if it hasn't been sent to collections already, it can be now.
Your Honor, I paid all my fines.
You did?
Yes, Your Honor, I did. In full.
Okay. Can I get confirmation of that from perhaps from Ms. Ashenfelter from Community Corrections?
Yes, Your Honor. I believe she did that while she was being supervised in Topeka.
All right. Again, one of those small successes that you had in the case, Ms. Ginsburg, at least that's something that's not going to be chasing you around. The court will be remanding the custody of Christy Rose Ginsburg back to the Butler County Sheriff's Office until her custody can be transferred to an appropriate Secretary of Corrections facility to serve the remaining balance of the modified 20-month sentence, which the court has imposed here today. All right, Mr. Baca, are you aware of any other matters which the court needs to specifically address on the Ginsburg case?
I'm aware of no other matters, Your Honor.
Thank you. Mr. Favre, anything further?
No, Judge.
You have any questions, Ms. Ginsburg, about the court's orders today?
I do not, Your Honor, and thank you for understanding.
I would only suggest that you take advantage of any program offered within the Department of Corrections that might assist you in earning good time credit or helping you toward rehabilitation so that you're successful when you get out.
Yes, Your Honor. Thank you.
Very well.
Judge, I apologize, Judge. Did the court waive attorney's fees for this round of hearings?
I did.
Okay, thank you.
There's nothing further then. The Ginsburg matter will be in recess at this time. We'll move on to another case.
Thank you.
All right, Mr. Watts, do you have Mr. Camplin?
I do, Your Honor.
Office?
Is that court security?
Okay.
And he's on his way. He's just moving a little slow.
Yes, Your Honor.
You're the CSO on this case, correct?
I am, Your Honor.
Okay. Do you have a breakdown of what Mr. Camplin owes and what he owes for?
I can get that to the court, Your Honor.
Okay. I'm just going to let you know that I'm going to be asking for that later.
Yes, Your Honor.
I'll go ahead and call the case. This is State of Kansas versus Warren William Camplin III. It's case number 2024 CR 316. Mr. Camplin appears from the court security Zoom location at the Butler County Judicial Center. James Watts appears as defense counsel. Joseph Baca as prosecuting attorney. Also note Ryan Smith from Court Services, who's the probation officer assigned to the case. This matter comes before the court at this time for a warrant to show cause alleging probation violation. The allegations are the defendant failed to report as directed, and he's failed to pay as directed. We're going to look for the specifics on that. He had an $84 per month payment requirement each from the beginning. Defendant hasn't met that requirement according to Mr. Smith. And that apparently the defendant allegedly has missed 4 scheduled appointments to meet with his probation officer. One in June of 25, August of 25, November of 25, and February of 2026. What are your client's intentions regarding these allegations, Mr. Watts?
Your Honor, I've spoken with my client. He would acknowledge he's missed appointments in this case and would also acknowledge he has not made his payments in a regular fashion. Would stipulate to those violations.
Thank you, Mr. Watts. Mr. Camplin, you've been present when your attorney made an announcement that you would now waive any due process hearing that you'd be entitled to, where the state would have the obligation of proving these allegations by a preponderance of the evidence. You could challenge the state's evidence, present your own evidence, confront the state's witnesses unless good cause was shown, and among other lesser remedies, Mr. Camplin, the court could consider an outright revocation of your probation and having you serve the remaining balance of your sentence locked up. Do you understand these things?
Yes, I do, Your Honor.
All right. Do you waive a formal hearing in this case and stipulate and agree that you committed these 2 violations of failing to pay as directed and failing to report as directed? It's not a trick question.
No, I know it's not. I know. Yes.
Okay. I'm a little concerned about the hesitancy.
Yeah, I
Mr.
had
Camplin,
good reason.
usually
I had
people
good-
don't hesitate like that.
Well, I had good reason, but
You
things
can
happen.
explain some circumstances to me
Things
later. if you
happen,
think
they
it's
happen.
personal.
I know, I'm not trying to. That's why I just said yes. That's why I said yes.
Okay. After some contemplation, it does appear that the defendant does waive a formal hearing in this case and stipulate and agrees that he's committed the violations as alleged, which are fairly straightforward: failure to report on 4 occasions and failing to make the payments as required by the court. These are substantial and material violations of the terms and conditions of Mr. Camplin's probation, which was granted I'm reading my own notes here. It was granted back on April 1 of 2025, following a plea of no contest to the charge of mistreatment of a dependent adult, a Class A misdemeanor. The court did impose 12 months in the county jail, but granted an initial 12-month reporting probation period, including the requirements as outlined earlier, which this defendant stipulates that he did not meet. Having now accepted this defendant's waiver of hearing and stipulation, I'll ask for recommendations regarding an appropriate disposition. I will begin with Joseph Baca on behalf of the County Attorney's Office.
Thank you, Your Honor. Well, Your Honor, while I understand that there has not been any prior violations on this case, we are reaching quite some age in this case to where we're hitting not reporting and not paying on the case. I think based on that, I'm willing to go along with the recommendations that the court service officer put in their request for revocation, which is to revoke his probation, request the defendant serve a 10-day jail sanction, after which would be fine reinstating probation and extending it for 1 year. I think part of the cost he owed is also a bill to a life care facility that really hope he understands that that money's important to them, and that's a big part of our request today.
Okay. Thank you, Mr. Baca. Mr. Watts, your recommendations regarding an appropriate disposition?
Thank you, Your Honor. The recommendation that 10 days is a reasonable one. I would note that Mr. Camplin has already served considerably past 10 days in this case. He came into custody, and I don't remember the exact date, but is well past 10 days. In fact, it's past 30 days. He bonded out just a few days ago on this case. So should the court impose that 10-day sanction, I would ask the court to consider that 10 days. The time that he's already served is fulfilling that 10-day sanction.
Do you have an exact number of days he served?
He was arrested on March 4th, according to the return, and my understanding that he bonded out early part of this week, if I remember correctly, if I understand correctly, Monday or Tuesday.
Does anyone have access to the exact date of his release on bond?
April 20th, Judge.
Thank you. Then it looks like the computation would be 47 days. Anybody disagree with that?
No, Your Honor.
All right. All right, Mr. Smith, you've heard the recommendations of the attorneys. Do you have some independent input for the court?
No, Your Honor. Just I am recommending that he serve 10 days, which it sounds like he served more than 4 times that amount at this period in time. I will tell the court that he has paid some additional costs and fees since the filing of this warrant to show cause. He has paid an additional $180 in the case. I will also inform the court that the only remaining balance due to the court is a restitution balance, and that current balance is $22,987.
Who is the recipient of the restitution money once it's paid, Mr. Smith?
Your Honor, the victim in this case is...
I don't remember the particular name, but it's a nursing home, Your Honor.
I thought that it was mentioned during the sentencing hearing.
Well, it should be chronicled in the original journal entry.
I think it's the Life Care Center, and I don't remember where they're exactly there at.
I don't believe it's actually spelled out in the journal entry, Your Honor. That's why I'm looking at the prior court's notes in the case.
Your Honor, the journal entry that I'm looking at has the restitution due to the estate of Melissa Morton.
That's consistent with what I see in case notes.
But I believe that restitution is being applied to a care facility.
Life Care Center was mentioned in the original charging document.
Yes, Your Honor.
Okay. Mr. Camplin,
Yes.
at this time, I'll ask you if you have any statements that you wish to make in mitigation of punishment or anything further that you would like to present to the court.
I'd like to touch on a few things.
You certainly may, Mr. Camplin.
On the days in question that I missed probation, I don't remember those days, but I do remember calling in, but they had to be moved ahead because of a scheduling problem they were having. I know that happened at least 3 times. And I know I had a big problem. I had people shooting guns out in front of me in a motorhome I was living, and I was being told to move at the same time. It happened 2 nights in a row. And I never could get the motorhome started, so I just had to leave. But in the process of trying to get out of there, for some reason, the batteries in the motorhome had gone bad, and I had to spend what money I had to buy these batteries, which are about 180 a piece for a cheap ones. That will start them, but you can't run anything off of them, but it'll start them. But it wouldn't start the truck. I had problems with ignition lights when I turned the key on and off. And I remember that, and I remember calling Mr. Ryan and explaining to him what happened to that money. But I knew it wasn't, but I just wanted to call him and let him know that I wasn't doing it on purpose, that I was actually under some distress during that period. And then, unfortunately, on February 3rd, I had gone to pay a storage unit, and on the way back had a flat tire and had to drive about 3 miles with it flat to get to where I was staying, which I was homeless and I was just parking and living at the time. And that was on the 3rd, and I did call and make I did call and leave messages that I had had a flat tire, and also on that day had tried to call court services to pay my fine, but it kept refusing me to pay it. And I paid it last in January. I paid it online, but I wasn't able to pay it in February the 3rd online. So I called the phone
You tried to call court services to pay it?
No, there's a website you can go to.
Okay.
It's a website you can go to where you pay them, and I did it in January, so I needed to do it again because of this flat tire plus the cost of the gas back and forth, of driving to El Dorado to pay it and coming back and all that. But they wouldn't let me, so I called an information number at the bottom of the page, and I explained to them what happened, and this is what they told me. Even though that I had told them I had paid a payment in January, why can't I pay one in February? Is they told me it all had to be paid. That they made a mistake letting me pay it that one time. So I had to live with that. And I called and left a message with my probation officer, Mr. Ryan, that had happened. And I had that flat tire. I couldn't go anywhere. And the problem with that is I don't know anybody, don't have any friends. I know some of Melissa's friends, but I'm not friends with them. I'm just, So I didn't have anybody I could turn to try to get to the post office to get a money order, to get the address of the courthouse here, to have it mailed to the office down the hall. And I thought, well, I need to get a tire so I can drive to El Dorado to pay it. So here I was. I could not find that particular size of tire used anywhere in Wichita. I found it out of town. I found 2 in Abilene. I found one in Coffeyville, another one in Manhattan, but I couldn't find anybody to do me the favor of helping me go to get it. And I waited and waited and looked, and I finally had to give in to a new tire. I have a receipt here from the tire place where I bought it near where I was staying. And it was basically my fine money. But the tire cost me $98.35 new. And I didn't want to do that, but I was thinking, if I don't do this, how am I going to show up to my probation officer appointment on the 3rd in March? Because I'm already at the 17th, right? Plus, I was running low on supplies. I needed more water, and I needed to make a run to a place for my pets for some food because I was running low on the cat food part of it. I had plenty of dog food. No, please don't try to call me in the middle of this. Jeez, I'm sorry. Let me turn my phone off. Sorry. But I tried to do all this, but for some reason I just kept hitting brick walls, and I knew it. And I knew it was a problem when I couldn't pay my fine in the first place. That's why I held on to the money for so long, because I was hoping to be able to get to El Dorado or get to a post office to get a money order to mail it. Because I had called in to get the address that I needed and the office number and all that. So I had all that information. And I never got it done. And I ended up having to use that money for the tire so I could actually make it here in March to pay my fine and see my probation officer, Mr. Ryan. And as far as I remember, I was put on probation in 2024. I don't remember what month, but I know it was in 2024 because in 2025, Melissa passed away in January of 2025. So anything after that, I never went to court. I'd already been going to probation before January.
You were put on probation according to the court's record here, April 1 of 2025, Mr. Camplin.
That can't be right. I mean, it was Melissa passed away in January 2025. Your Honor, something's not making sense here because before
Agree with you
January
there.
before January 2025, I was barred from being able to go see Melissa. I actually met a couple of nurses that work here in El Dorado while I was incarcerated that used to work at the nursing home where Melissa was. And they remembered me because I was there all the time, pretty much 3 days a week, Saturday and Sunday, and but I recognized one of them. I didn't recognize the other one, but I recognized one of them. And so I wasn't able to go see Melissa. And when she died in January, my first thought was, well, it was under scary circumstances, I can tell you that much. But as I was called by both hospitals that she was at, they called me, they didn't call them. They called me. Before she passed away, she went to Western Medical Center and then went back to the nursing home and then was sent to St. Francis, which is now Via Christi. And then some, questionable things they told me about, questionable all over the place. But I'm just trying to put a placing pad or placement in where things happen. If Melissa had already passed away in January and I didn't get put on probation until April, it wouldn't match my receipts on my debit card when I came to the office to pay my fine. And the reason I quit using my debit card in the office is it cost me extra money. So I started bringing in cash, $80 cash, because it was cheaper. I'd only have to pay $80, but it was $4 if I used my card, just a long thing like that. And then I found out that I could do it online. So I started to do that this year in January. But I was trying, but I know I failed. But My hands were a bit tied. I would have liked to have walked to get to places, but I can't anymore. I would like to have done a lot of things different. Your Honor, thank you.
Your Honor, if I may, I wanted to point out that 2 of those meetings he missed were in-person meetings. 2 of the other meetings, however, were simply video phone call meetings. So I was having him try to report virtually as much as possible. I just wanted the court to be aware of that.
Thank you. And what date do you show the defendant was originally placed on probation, Mr. Smith?
April the 1st of 2025, Your Honor.
Consistent with the court's docket records. All right. Thank you, Mr. Smith.
Yes, Your Honor.
Okay. Mr. Camplin, I've listened. I gave you some latitude here regarding your statement to the court, and I've heard about your statements regarding guns, tires, motorhomes, dog and cat food, and your remembrances of the late Ms. Martin. But the bottom line is that this court expects, while you're on reporting probation, to report each and every time that you're required to by your officer, especially one who's willing to work with you regarding remote access. And apparently you have a phone, so you referred to that here as part of your statement. So furthermore, the court also notes that apparently since Ms. Morton has passed away, this court is aware that one reason why you were convicted of mistreatment of a dependent adult is that funds were removed from her personal accounts by you, precluding the ability to pay Life Care Center for her care. And so it is appropriate for Life Care Center to be substituted for any prior statements in the record regarding Ms. Morton's estate, since apparently, as far as I know, there is no estate that was ever opened for her. And Life Care Center was essentially the compromised party by your failure to make payments to them instead of taking money out of her accounts for who knows what purposes. This court at this time will revoke the probation of Mr. Camplin, reinstate it after he serves 2 more days as a dip sanction for failure to comply with probation requirements. This court is aware that Mr. Camplin previously served 47 days in jail, and he'll get jail time credit for that. But it is intended by the court that this be a prospective sanction. So perhaps it contemplates that he'll serve 49 total days, 47 already served, 2 more to be served, effective immediately. Mr. Camplin, I want you to contemplate for the weekend that you have to meet your requirements in this case, or you're going to do all of the time that was originally imposed. And I'm just not sure you have that message yet. You always have explanations that you attempt to try to excuse your failure to meet your conditions. But I believe you need to take this 100% seriously, and I'm not sure that you do. Furthermore, this court wishes to inquire. Mr. Watts, you had submitted an order, which this court eventually approved, allowing him release from the previous bond order while this matter was pending. Did he post a cash bond, or was it surety? Because the file that I have before me doesn't reflect it. But I'm sure that he posted bond in some manner. Do you know what manner it was posted?
I don't know, Your Honor. His sister, Catherine Kelly, posted the bond. I don't know whether that's an entirely cash bond or whether she hired a bondsman to do that.
Mr. Camplin, do you know?
Yes, it was a cashier's check. Yeah.
Okay.
For the entire amount?
3,500.
All right. Mr. Camplin, Kansas law is fairly clear. Essentially, when someone posts cash bond for another, they are turning that money over to the defendant. And let me tell you how I construe the statute. Statute very clearly says that before a cash bond is returned, and it's to be returned to the defendant, that any costs that might be owed are deducted from it. Since you owe apparently over $22,000, I'm going to obviously direct, pursuant to an administrative order, which is already on file to make it self-executing for the clerks, that this $3,000 cash bond is to be turned toward payment on the case. Mandy, did you happen to confirm that it was a cash bond posted?
I'm showing a cash bond of $3,000.
All right. I'm going to, obviously it's I just want to explain to Mr. Camplin that it's going to be the procedures of the court to apply that to your case.
It
Okay.
wasn't my money, Your Honor.
Huh? Excuse
It
me?
wasn't my money. It was not my money that did it.
Oh, I don't think you just heard what I just said.
I heard, but I'm saying that there's a innocent victim here happening if her money's taken
No,
when she
no,
was told.
That person turned over money to you to post bond.
Right. And she was told that if I showed up to court, she would get it back.
I don't know who told her that, because I guarantee you that I didn't tell her that.
No, I know you didn't, Your Honor. There's no way you're on the other end of a phone when she's calling about bonds.
Okay, well, I'm not responsible for erroneous information that somebody else tells her. But I'm not aware of a statutory exception which allows the court to exercise discretion to return the money to anybody but you. And that it does call for the application of that cash bond money toward obligations on the case. I believe the statute, well, I don't want to cite the statute unless I know I can cite it.
There's a
Specifically.
lot of them. There's a lot of them.
Yeah, there are a lot of statutes out there, Mr. Camplin.
Yes, Your Honor. Yeah.
But that will be the directive of the court. Again, consistent with the administrative procedures already in place. Mr. Camplin, I also
Yes.
want to know what financial resources do you use now to support yourself?
My Social Security.
Okay, and how much do you get in Social Security?
It went up to $940, I think, because some tax savings or something.
Okay, good. I'm not going to raise your monthly payment requirement. Whatever was established before, I'm going to keep in effect. I think it was 84 a month minimum.
Well, it was 80, but I was paying 84 if I used my debit card in the office down the hall, Your Honor.
Must pay $84 a month starting April 2025. It's part of the notes of the April 1, 2025 sentencing.
April? Your Honor, I lost a storage unit. That had paperwork of my case in it. And I lost that storage unit in January of 2024. Yeah.
And your point is what exactly?
Well, I need that paperwork, but I can't get it anymore. Or I'd be able to
Okay.
show my attorney, but I can't even get to it anymore. It's gone.
Okay. I'm going to request Mr. Smith from Court Services. Mr. Smith, at the next in-person appointment you have with Mr. Camplin, can you have a copy of his journal entry of conviction and sentencing and his probation conditions that you can give him anew so that
Yes,
he can be there with that paperwork?
Yes, I can, Your Honor.
Thank you. I appreciate that. I think that would help Mr. Camplin out to be aware of everything that's gone on in the case that's pertinent at this point. And if you have it, perhaps a copy of the journal entry which stems from today's proceedings.
Yes, Your Honor.
Mr. Smith, I appreciate your service to the court in that regard and to Mr. Camplin. Did you want
Yes,
to say something else, Mr. Camplin?
I just remembered something. The house I'm staying at, if I don't show up by midnight tonight, I'll get kicked out of it. I won't have a place to go when I get out of jail.
I don't know what circumstances led to that,
Yeah.
but you're going to be serving the next 48 hours in the jail, Mr.
I
Camplin.
understand.
And
I understand.
you're not going to be available
No, I
tonight.
understand that. No,
Okay.
I was totally innocent. Yeah. Take me in.
And I hope that that you don't suffer any property loss or anything because of the incarceration order the court's made.
Well, I had to live there and I had to have things there.
All right, Mr. Baca, is there any further clarification you need from the court regarding the court's orders made here today?
I don't believe so, Your Honor.
Okay.
Judge, I don't think the state has anything.
Okay.
Your Honor, I do. I'm wondering if the court is extending the defendant's probation, and if so, for how long?
12 months from today's date.
1 year from today. Thank you, Your Honor.
Yes, and it very well may be that further extension may be required in the future. Mr. Smith, I recognize that, but I think I'm just going to extend in this case in a 1-year duration.
Okay. Thank you, Your Honor.
All right. Because of the court's order for a 2-day dip sanction to be carried out immediately, Mr. Camplin is ordered to be in the custody of the Butler County Sheriff's representatives there at the Judicial Center until his custody can be transferred to the Butler County Jail to serve 48 consecutive hours in the Butler County Jail as a sanction prior to being released back on probation. Don't wear a hat in court, Mr. Camplin.
Sorry, Your Honor.
Okay.
Thought we were gone.
If there's nothing further, then the Warren Camplin matter will be in recess at this time. Counsel, it's court's understanding that that concludes the docket. Mr. Baca, do you agree?
I do, Your Honor.
All right, very well. With no other business to come before the court at this time, this docket is concluded. The meeting may be ended for all.
This is a bench warrant arraignment and a criminal arraignment in several cases versus Patrick Bernard Jones. Is that you, sir?
Yes, sir.
Mr. Jones, you got picked up on a bench warrant last night on file 251956. That's a retail fraud in the 3rd degree that allegedly occurred on September 8th of 2025. You posted bond back in December of 2025. We had an attorney pre-trial, and you called and said you couldn't get there. That was January 2nd. We reset it to February 6th, and you didn't show up on February 6th. You called and said you couldn't get a ride. So they tried again through the month of February and never showed up. So we issued a bench warrant in February for your failed to appear on that retail fraud charge. Your attorney is Paul Gibson. In addition, you have several new charges or other charges.
Yeah, 2 trespassing charges.
All right, file 252307. You're also charged with retail fraud. In that case, retail fraud in the 2nd degree, which allegedly occurred in April of 25. Same sequence of events. You got arrested, you didn't show up, you failed to appear, and you continued to fail to appear. Then you have 2 new charges.
Hey, stop talking.
Which are trespass. Just a minute, only one of us can talk at a time. It's alleged that on December 31st of 2025, you trespassed in the city of Sturgis and filed 252719 and trespass in the city of Sturgis on December 11th of 2025. They sent you a notice of arraignment for January 28th. You didn't show up. They did a shoot cause. You didn't show up for that.
I did.
And so then they issued these warrants. Then there's another one. 21258. Oh, that's an unpaid trespass. And there may be another 2370, 2320. I guess that's it. So you have 2 retail frauds that you failed to appear for and 2 trespasses that you failed to appear for. The distinguished gentleman appearing with us here is Mr. Keith Stickley. He is the Chief Public Defender. How did you get arrested last night?
I turned myself in last night. I knew that I had warrants and was going through some things with the home that I was staying in. The guys tried to basically take over the home that I stay in, that I was paying rent in, and I had to call the police. And, you know what I'm saying? I had to turn myself in just to deal with that, just so police can deal with that.
How did you go about turning yourself in?
I called the police, and the police came to where I was.
All right, where was that?
It was I was sitting at Walmart.
You called the police at Walmart and said, come get me?
No, I told him about the situation with the with what was going on with my home and the guys trying to take over my home. They tried to jump on me and I wound up getting away. And
hang on a second, sir. Hang on, sir. I'm gonna stop you right there because I sense I kind of know where this is going, and I'm not sure we're gonna help ourselves in a bad situation.
Yeah, okay. I think he called the cops and then they served these warrants.
Yes. Because I have a warrant.
Are you still at the Jean Street address?
No, sir.
What's your address?
917 East West Street.
Sturgis?
Yes, sir.
Are you employed?
Yes, sir.
Where's that?
I do landscaping at Sleazy's Landscaping. I don't know where this place is, but I just work with the guy. I do landscaping with the guy. And I also just got a car too. That's the reason why I miss court. I don't mess with anybody. I don't mess with anybody. Like I'm a loner for real. And I just got a car so I can.
We're here all day, every day. Now, did you ever contact your lawyer?
No, I contacted the courts. I did contact the court. As a matter of fact, yes, I did. I did contact my attorney.
All right, well, let's reset all these for May 1st at 9 a.m. That's the next available date. With Mr. Gibson. He was here earlier, but he left to go to Three Rivers.
And another thing, I didn't know nothing about the new cases. I didn't get anything in the mail about these new cases, these trespassing cases. I didn't know anything about these cases.
Okay, fair enough. Oh yeah, I think you got a ticket. Warrant mask. You got a ticket that told you to appear with it on January 6th at 8:15. So those weren't a total surprise. Bond is $250, cash or surety in each retail fraud case. Bond is $50, cash or surety in the trespass cases. This is the kind of cases that could probably be resolved if we get you, the prosecutor, together, all at the same place and the same time. Do you have any warrants from anywhere else?
No.
Very good. You've been kind of playing fast and loose with the rules. You failed to appear on multiple cases. You failed to appear on 2 separate trespass cases on different dates. You failed to appear multiple times on the retail frauds. You didn't show up on the 2nd. We reset it to February 6th. You never called your lawyer. You didn't show up on February 6th.
I did, sir. I promise you. I promise you I did. I always call. I never just not call. Like,
well,
I promise
then you didn't show up. So we reset it for your benefit on February 6th. You didn't show up then. Then you never showed up again. We're here all day, every day. We dinked around with this during the whole month of February, trying to get you in here. You never called your lawyer then, and you never called us. So you didn't exactly turn yourself in. You called the police, and they served these open warrants. So If you post these bonds, the total would be $600. If you don't post the bond, I will see you next Friday with your lawyer present at that time. And I will let Mr. Gibson know that you're presently in jail and he can come discuss this with you. All right, good luck, sir. I'm not sure as a marketing tool, I would want to call my business Sleazy's Landscaping Service, but doesn't make you want to run out and hire the guy. But you never know. You might
You
need
never
some
know.
landscapers. Maybe we'll get the number, how to contact them. All right, thank you, Mr. Stickley. That's it for me for this morning.
All right. Have a good day, Judge. Thanks.
I'll get that number for you so you can. There. Sleazy's Landscaping. All right, Mr. Jones is struggling a little bit. We'll stop the live feed. We'll deal with him next Friday.
Brown. Mr. Pickett, are you ready? We'll be on the record in GW 2026 TR 91. State of Kansas versus James Dale Pickett.
Yes.
Paulie Dean for the state. Defendant James Pickett appears in person and pro se. I have you down for a bench trial starting at 9 o'clock. Are you still wanting a bench trial, Mr. Pickett?
For the traffic ticket?
Correct. Right. Speeding 95 and a 65, failing to wear a seatbelt. I show you down for traffic today, and it looks like the state's ready to proceed if you want a trial.
Okay.
Is that what you're expecting today? Is I show you we're pleading?
No, that wasn't what I actually haven't had time to get, or well, I'm trying to get counsel, but.
Well, I show you were here March 24th of 2026 for the first appearance docket. We went over the charges and your rights, possible penalties. You pled not guilty. You were going to hire an attorney, and we set it for trial for today at 9 a.m.
Okay.
So how are you planning to proceed today at this time?
I'll go ahead and go on to it.
You want to go to trial with representing yourself? I'm sorry, I'm not hearing your answer, Mr. Pickett.
Yes.
Okay. And you understand that you could hire an attorney. I can't appoint an attorney because of the fact that these are citations. There's no jail time, but you can hire one, and you understand you had the chance to do that and did not do so?
I haven't been able to.
All right. And so now you want to waive your right and proceed on your own behalf. Is that right?
No, I'd really like to get counsel.
Okay, well, you've had since March 24th, you've had exactly 1 month. What are you suggesting? You think some more time and you could get an attorney?
Had the tickets
Yes.
February 18th as well, Your Honor.
What's that, Mr. Dean?
This ticket's been outstanding since February 18th. I mean, that's when we definitely wanted to have an attorney, I would assume, but I'm not going to object. I'll leave it to the court's discretion.
Well, I feel like, Mr. Pickett, you've had a chance to get an attorney. We did talk about this would be set for trial today, so I'm basically prepared to proceed. If you're ready to proceed, we'll proceed.
Proceed.
I'm sorry?
Go ahead and proceed.
All right, Mr. Dean, you want to call your first witness?
I'd call Greenwood County Deputy Michelson to testify, Your Honor.
Please raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right. Please lower your hand and you may proceed, Mr. Dean.
Deputy Michelson, could you please tell me your, give for the record, your name and position or title?
Stephen Michelson, currently a sergeant with the Greenwood County Sheriff's Office.
How long have you served in that capacity, sir?
As a law enforcement officer?
As a law enforcement officer, yes, sir.
27 plus years.
And how long have you served as a sergeant?
Probably a year and a half or so now.
And what type of training have you had over the last 27 years in regards to interdiction of people exceeding the posted speed limits?
I went through radar and LiDAR training. Back in the early 2000s, I went to school to be a LiDAR radar instructor and just everyday experiences doing my job.
And is there any particular habit or custom you follow prior to deploying your radar device?
At the start of my shift each morning, I perform a internal self-test on my radar to make sure it's functioning properly. And periodically throughout the shift or the day, I might use my forks that are assigned to the radar to further check it again. And then the completion of my shift, I do another internal self-check.
All right, very good. And back on February 18th, 2026, at approximately 11:20 in the morning, what were you doing at that time?
I was patrolling U400 highway. I was originally traveling eastbound when I observed a vehicle traveling westbound at a high rate of speed.
And that vehicle happened to be a four-door Buick?
Yes, sir.
And was that around milepost 339?
That is correct. Approximately that area, yes, sir.
And were these observations, or is that location and the observations you made, did they all occur within the corporate confines of the borders of Greenwood County?
Yes.
All right. Once you saw the vehicle traveling at what appeared to be a high rate of speed, what did you then do?
Utilizing the front antenna on my radar unit, I was able to activate it, and I checked the vehicle speed at 95 miles an hour. I received a strong, steady, audible tone from my radar, indicating I had a good signal.
All right. And what was the signal, or what did you then do?
I'm sorry?
I said after obtaining that signal, what speed was your radar indicating?
95 miles an hour.
And what's the posted speed limit in the area?
65.
And what did you then do after obtaining that reading?
When it was safe to do so, I performed a U-turn because I was traveling eastbound. The vehicle in question was traveling westbound. And I began to activate my emergency equipment, and I closed the gap, conducting a traffic stop on the vehicle.
All right. And how did the vehicle respond to your emergency lights?
Once I caught up to it, he yielded. He pulled to the right and yielded appropriately.
And were you able to make contact with the driver?
I was.
And do you see that driver with us here today?
It'd be Mr. Pickett. On my computer, he's in the top right corner as I look at my screen.
It says James Pickett. Is that the screen you're referring to?
Yes, sir.
And were you also able to identify him with a true driver's license?
Yes, he provided me with documentation, sir.
All right. What observations did you make of Mr. Pickett? Yes, Mr. Pickett, when you approached the vehicle?
Just informed him of the reason of the stop. He was not wearing a seatbelt. I inquired if he had a medical exemption or reason to not wear a seatbelt. And he just said that he's big and he doesn't wear them.
Did he make any statements to you about his speed?
I believe it's been several months, but I think it was in the reference he wasn't paying attention.
After that contact and identification, obtaining his documentation, what did you then do?
I proceeded back to my vehicle, wrote the citation, and went back into my vehicle and issued the citation to him and completed the traffic stop.
Your Honor, if I haven't done so already, I just note as the record reflect that Sergeant Michelson has identified Mr. Pickett as the defendant in this particular case.
The record shall
Wasn't even
say.
an officer.
I'm sorry, Mr. Pickett, what did you say?
That wasn't the officer that pulled me over, but it's not relevant anyways. I'm sorry.
Well, you'll
Go
get your
ahead.
chance to present your defense, but I will have the record reflect that the witness, Sergeant Michelson, did identify the defendant, James Pickett, as the driver he stopped, also James Pickett. Anything further, Mr. Dean?
Mr. Michelson, based upon that, have you changed your appearance in any significant way since this traffic stop?
I've shaved my beard off, I guess, my goatee and beard, yes.
All right. I have no further questions. Thank you, Your Honor.
All right. Now, Mr. Pickett, can you still hear me okay?
Barely.
I do have a way to increase my volume. Maybe that will help you.
Yeah, I'm
Okay.
listening.
Mr. Pickett, now is your chance, if you wish to cross-examine the officer, to do so, to question him about you said he wasn't the officer that stopped you. If you want to talk to him about that, question him about it, now is the time to do that. You can't testify yet. It's not time.
I guess give me the ticket. I'll pay it.
Well, are you saying you want to stop the trial and enter a plea of guilty and pay the ticket? Is that what you just said, or basically implied? Or do you want to cross-examine this witness?
It's not the officer that pulled me over, right? I know that.
Hey, why don't you ask him about that if you want? He just said he did, but you could ask him any questions.
Hey, the officer was younger. I don't know what I'd ask him. He's saying he's the one that was there, and there's no way to fight that.
Well, if there's anything you want to ask him to question his credibility, to show me that he wasn't the officer that was there, I'll sure allow you to do it. You're entitled.
Oh, okay. Were you there?
All right, Sergeant Michelson, the question to you is, were you there?
Yes, I was. I was alone. I was alone when I contacted them.
Talk to each other. Don't talk to me.
Yeah, I was alone when I contacted you.
Any follow-up on that, Mr. Pickett?
No.
Okay. All right, any redirect, Mr. Dean?
No, Your Honor.
Any other evidence, Mr. Dean?
A state would rest at this time, Your Honor.
All right, now, Mr. Pickett?
Yes.
The state has just rested. That means they've presented all the evidence they intend to for this trial. Now it's your turn to present evidence. You can testify yourself if you want. You don't have to, and it won't be used as guilt. You can call any other witnesses you might have, even this officer as your witness if you want.
There's nobody else there.
Okay. Do you want to testify yourself then?
What?
Do you want to testify, that is, tell me what you remember about the incident?
It seemed to go the same way he said, but as I said, it's not him.
Let's hold on. Raise your right hand, please.
Yes.
Mr. Pickett, let me see your right hand if I could, please. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. Now, please state your name for the record.
James Pickett.
Okay. And you're the defendant in this case, correct? That is, you're the one charged with speeding 95 and a 65 and not wearing a seatbelt on Highway 400 in Greenwood County, Kansas on, where's the top of that ticket? On February 18th, 2026 at 11:20 in the morning. You're the defendant accused of that, right?
Yes.
All right. Now, what do you want to tell me about February 18th, 2026 around 11:20 a.m.?
I was driving and then all of a sudden the cop behind me, and I pulled over, did as everything said, but that's not the officer that was there.
Okay, anything else?
No.
Okay, Mr. Dean, any cross-examination of the defendant?
Briefly, Your Honor, Mr. Pickett, I take it by your statements that you acknowledge that on February 18th, somebody from Greenwood County Sheriff's Department stopped you for speeding, correct?
Yes.
And that you weren't wearing your seatbelt. Is that correct?
Yes.
And it sounds like you even acknowledged that you were speeding on that date. Is that correct?
I guess I was, like, as I said, I was driving.
All right, I have no further questions, Your Honor.
All right, any further evidence, Mr. Pickett? Any other witnesses?
No.
Very well. I do find, Mr. Pickett, then, that you were speeding and not wearing your seatbelt as alleged. I find it very interesting that you're saying that was not the same officer you recall, and yet he's very adamant. But in any event, the evidence is uncontradicted that you were speeding as alleged of 95 and a 65 without a seatbelt, so I will find you guilty of both charges. Recommendations for sentencing, if any, Mr. Dean?
Schedule fine, Your Honor, and set a time for failure to appear.
Okay, Mr. Pickett, anything you want to say about sentencing before I tell you what it is?
Your Honor, can we go ahead?
Something about failure to appear is what he just said?
No. All right, sir, your fine on count one speeding, 95 and a 65. The scheduled fine for that is $190, and that will be the order of the court. On count two, failing to wear the seat belt is, as I recall, a $30 fine. Mr. Dean, do you agree that that's the seatbelt charge is 30?
190, 30, and 108 court, I think is what we're at.
That's what I'm finding too, is what $30 for that second count of the seatbelt, 108 for court costs. So the total owed is $328. Is that what you got, Mr. Dean?
Just a second, Your Honor.
Okay.
I got 337.
Okay, 190, 30, and 108. I'm not sure where you got the 7, unless I missed.
8 is 17.
But it's 190. $190 plus $30.
Oh, 90. I'm sorry. I wrote down 199. Yes.
Oh, well, did I look at it wrong? Let me double check.
No, I misheard you, Your Honor. You said 190. I wrote down 199, so yes.
Okay, so 8, 12, so 2, well, now it's 328, right? Carry a 1. 328. The clerk will have the official amount that you owe, Mr. Pickett, but the fine is
328. I agree with you, Your Honor. Now that I took $10 away.
Actually, I think the scheduled fine was 195, but I'm gonna leave it at 190.
I'm gonna stop.
Right.
I'm just making it work. I take it Sergeant Michelson could be released now, Your Honor.
Yes, and how much time do you need to pay that?
Thank you, Your Honor.
You're welcome.
Have a good day.
At least.
Thank you, sir.
You know, bills and everything.
It's about 328. 60 days, 90 days, 120 is probably about as far as
90.
90 is enough. You think that's a little 30 a month? Okay, I'm gonna give you 90 days from today to have that paid, and I'm gonna give you a court date to come back if you don't have it paid. Missy, when's a pay or appear for him? About 90 days out.
You what?
How long out?
90 days. I'm asking my assistant Missy to give us a court date.
Well, man, I turned it off, bro. That's wrong, bro. The man
Hang
said
on,
that's
Vic.
gonna get my life back.
Mr. Miller, please mute yourself while I tell your case.
Hold on.
July 31st at 11.
All right. July 31st at 11. Okay, Mr. Pickett, You have until July 31st at 11 to have that ticket paid in full, or you must reappear by Zoom, and we're going to talk about what's going to happen. If you want to find out the different ways to pay, such as online, mail, and so forth, please call the Greenwood County Clerk at 625, the Greenwood County District Court Clerk. That word district is very important because we have a county clerk and we have a district court clerk. And
Victor, go ahead and mute.
What?
Hello?
Mr. Miller had unmuted again. Go ahead and mute and turn off your camera, Victor, please. Sorry.
No, thank you, Mr. Cooper. All right, Mr. Dean, anything further?
Did you review his appeal rights with him, Your Honor?
No, I didn't, but I will. Mr. Pickett, are you still with me?
Yes.
You have 14 days to appeal this decision with the Kansas Court of Appeals. If you do appeal, I'm going to order that you pay a cash appeal bond of $328.
Okay.
All right, now, Mr. Dean.
Yes, Your Honor. Just about done. Okay, Mr. Pickett. Every time we conduct a hearing, such as the trial we just had today, we have to do what we call a journal entry. It's just a record of what we've done. If you'd look at your screen, this journal entry just has the state of Kansas versus yourself. This is the case number that was assigned to this case. This is the date we appeared. We conduct that you appeared pro se, that you waived counsel on the record. You were found guilty of count 1, speeding, guilty of count 2, no seatbelt. And then down here, we set the court costs at $108, prescribed by the state of Kansas, and it's set statutorily, and we can't change that. $190 for the speeding is the fine, $30 for the seatbelt. You asked for 90 days to pay. The court gave you 90 days to pay and set this for a pay or appear for July 13th, 2026 at 11 a.m.
That's not 90 days. Oh.
July 31st.
Oh, July 31st. Sorry. Well, that's what I wrote down, but I'm reading it backwards because I'm looking at it in my screen. So you agree that says July 31st? All right. Then also the court advised you of your rights to appeal and set the appeal bond at $328, which is also the amount that's owed on the case. Do you agree? Not necessarily with the court's findings, but that's what the court found and ordered today. Mr. Pickett, do you acknowledge that's what the court said? That's what the court
like I said, it's 90 well,
I believe it's actually over 90 days because we're April 24th, and then you've got through to May 24th and June 24th, and then we'd be July 24th. It'd be pretty close to 90.
Okay, that's fine.
And then you got another week. So if you pay it sooner than that, you don't have to come back on that date. That's why we call it a pay or appear. So if you pay it, it's all taken care of. You're done here. And again, you have the right to appeal to the Court of Appeals. And I'm going to put down that you agree that that's what the court found and ordered today, and we'll get this filed.
And that's 14 days.
Yeah, 14 days, sir.
Okay.
Anything further, Mr. Dean?
No, Your Honor.
Anything further, Mr. Pickett?
No.
All right, thank you, Mr. Pickett. You're excused at this time.
Thank you.
You may go. You're welcome.
Is Hicks here? Hicks calling the case of SP 4672973, State of Michigan versus McKinley Scott Hicks.
Yes, I'm here.
Okay, you're Sergeant, please state your name.
Yes, ma'am. Sergeant Stephen James, Michigan State Police Metro North Post.
Good morning, sir. And defendant driver, please state your name.
McKinley S. Hicks.
Okay, sir, were you present for the first hearing where I laid out all of the rights and remedies?
Yes, ma'am.
Okay, do you need anything repeated or expanded upon?
Negative.
Okay, what is your choice, please?
I cannot agree to this.
Okay, you want to deny responsibility?
Absolutely.
Okay, so let me just tell you something. If you deny, okay, it's going to be all or nothing. And if you admit responsibility and then,
I understand.
okay, it's okay, but I want to let you know, construction zone 25 and over is 200, whoops, is $355 and 5 points. So if you lose, that's what you're looking at.
I understand.
5 points and $355. And you understand that it's an easy burden of proof. It's not criminal where it has to be beyond a reasonable doubt.
It kind of, so that's the thing. It kind of is criminal because he's saying that I was doing.
Okay, I don't want to get into it. I'm asking if you understand what you're facing.
I understand.
Because 5 points is brutal.
Absolutely, it is.
Okay, so at the end of the hearing, if I find you responsible, you're not going to get any grace. There's not going to be any point. Like, it's all or nothing. So I'm happy to give you the hearing. But I just want you to be clear because the other people admitted what they were doing and they walked out with something way less.
I would love that, but
okay, I'm going to give you your hearing. Raise your right hands. Do you swear or affirm that the testimony that you will give in this informal hearing is true?
Yes. I do, magistrate.
Okay, let's hear from the sergeant first. Hang on one second. Go ahead.
Yes, ma'am. On March 31st of this year at approximately 11:30 in the morning, I was on patrol westbound I-696 freeway near Woodward Avenue in the city of Royal Oak. Westbound 696 freeway is a posted 60-mile-an-hour construction zone. At that time, I was traveling in the left lane at an approximate pace of 60 miles an hour.
Okay, hang on. You're on 696. You're going westbound. You're driving on the other side of the road, but going west. Like you're in the construction. Okay. And what were you doing?
I was traveling at an approximate pace of 60 miles an hour in my patrol car. While doing so.
How do you know that? You saw that on the dashboard?
Yes, ma'am.
Okay.
While doing so, I observed Mr. Hicks's 2008 orange Suzuki motorcycle, which is a sports bike, merge from the left lane to the middle lane and begin rapidly accelerating and passing all traffic at a high rate of speed while closing on my patrol car. I utilized my rear moving
radar. So he was coming from, he was behind you.
Yes, ma'am.
Okay.
Closing on my patrol car.
He was behind you and catching up.
That's correct, ma'am.
All right. I'm with you so far.
While observing his vehicle, I utilized my rear moving radar of my patrol car to obtain a speed measurement reading. The speed measurement reading I received was 95 miles per hour. I maintained a clear tracking or observation of Mr. Hicks's orange motorcycle until he caught up to my patrol car. Where he passed my patrol car, I then initiated a traffic stop. I identified Mr. Hicks by his Michigan driver's license. At the time of the stop, I was both a certified speed detection and measurement operator, as well as a speed detection and measurement instructor, certified to teach other officers how to utilize radar and LiDAR and other speed detection measurement means. My radar unit was function checked at the beginning of my shift and at the end of my shift and passed functionality at both times. The radar unit utilized is standard issue by the Michigan State Police and has been equipped with the patrol car since its issue in 2024 and has been in good operation.
Did you make any conclusions on the rate of speed based upon your visual eye?
Yes, ma'am. His speed was consistent with the speed measurement I received based off the radar.
Okay. And the radar, hang on one second, I was taking notes. The rear radar was 95 miles per hour.
That's correct, ma'am.
And when that was read by the device, was the gentleman in the construction zone?
He was, ma'am.
Okay. Is there any other testimony you would like to present to the court?
No, ma'am.
Okay, and defendant, your turn.
So what happened was I was on 696. I was following the flow of traffic.
Okay.
There was no flying in the left lane and caught up to his vehicle. I seen him the entire time. Yes, he was in the left lane going, he was pacing about 60, 65 miles per hour. I was behind traffic the whole time. I see him. I've been riding many years. I'm 40 years old. I also run a group. There a group of riders. Is about 2,000 of us. I'm the founder of them. I am the guy who always tells other riders to be careful, ride in their own lane, try not to speed, and I respect officers. There's a lot of my riders that do fly. They pull away from officers. They run from officers. So on. But on this day, I was behind flow of traffic. And such, I was behind this a silver Kia. It was a Kia, a Stinger. Me and that
Okay, hang on. I'm drawing it. Okay, so the patrol car is ahead of you.
Yes,
and you're behind, and then there's a Kia in between you and the patrol car.
So okay, so me and
do I have it right?
Yes, correct.
Are you in? Let me ask you something. Are you in a construction zone?
696 is well. Sorry, eastbound is I don't even know because they turn on the eastbound into westbound. So none of it is a construction zone except for the other side of the barrier.
Okay.
But mind you, regardless, I'm sorry. Yes, that the whole freeway is considered a construction zone, but I wasn't.
So all right, let's get back to what was happening.
Yes, exactly. So
you have the patrol car and the Kia and the defendant.
Yes, so he was on the far left lane, going the speed he said he was going. I was in the far right lane behind a gray Kia. I remember the car. There was no vehicles in the middle lane. So when me and the Kia was coming up, mind you, my bike is loud. So I don't know if the sound of my bike triggers him or he's has some type of issue with other bikers flying and not stopping for him.
Is that the Kia driver or he being Sergeant James?
Sergeant James.
Okay.
Because I think bikes trigger him. And I'm gonna tell you this why. Because like I said, when I was behind the Kia, me, the Kia and Sergeant James, that's on the left side. I don't know what speed limit we were going because on a bike we don't really look at our speed limit unless we're not in front of another vehicle. But because I was behind flow of traffic, I wasn't really paying attention to my speed limit anyway. Because and especially me knowing that the Sergeant James is on the far left side. So anyway, what happened was. I felt like I was going too slow, so I was about to go around the Kia. I jumped in the middle lane, but then I realized I was like, Sergeant James is slowing down. So I slowed down and jumped back behind the Kia intentionally so I can avoid any problems with Sergeant James. Sergeant James, so what Sergeant...
if I'm looking down, I'm taking notes on what you're saying, but I'm listening.
What I want to say is me and the Kia did not pass such.
Okay, so you felt like you were going too slow.
So
you went the middle lane and then you saw Sergeant James and then you moved back behind the Kia.
Because I noticed Sergeant James' vehicle started slowing down. So my intuition told me, you know what, just get back behind the vehicle and just pace again. What happened was technically Sergeant James is in line because we did pass him, but that's because Sergeant James slowed down intentionally to get behind me in the Kia. But instead of him pulling over the Kia, which was doing the exact same speed that I was doing, he pulled me over.
Okay.
And then, like I said, I didn't even know I didn't even know he was gonna write a 95 miles per hour ticket until I seen the ticket.
Well, how fast do you think you were going? Because you just said that or testified that
Well, granted, I didn't know that on 696 was 60 miles per hour, but we was not doing 95 because me, the Kia, and any other vehicle that was on the freeway clearly seeing Sergeant James on the far left side and hit on his blue vehicle. It wasn't unmarked or anything. It was clear as day. I can guarantee you we wasn't doing 60, but we was doing nowhere near 95, let alone I don't even think we was doing over 75, but we definitely wasn't doing 60.
So you think you were going between 60 and 75?
I would say 60 and I would say 65 and 70, but 95 is outrageous. 95 is outrageous, even for a sergeant's standard. That's ridiculous. 95 is ridiculous. That's why I can't.
So do you think the radar is wrong?
See, he made a statement that it's been I feel like something's not right with this situation because I know I'm not wrong. I've been a driver for many years, and normally, if you look at my track record, if I ever caught a ticket or anything, normally I won't even have a hearing. I would just pay the ticket and I would just leave it alone. I've never asked for a hearing during a ticket at all. Normally, I would just move on and continue with my life. So this is all new to me.
Okay.
95 is outrageous.
Okay. Sergeant James, do you recall in this incident having seen is it silver Kia?
I do, ma'am.
Okay. All right. Thank you. So what do you recall about that? Do you have can you answer or respond to his testimony for the court, please?
Yes, ma'am. Mr. Hicks and I are pretty much in agreement on his statement. He was behind that vehicle, and as I initially testified, he merged around that vehicle and then began accelerating to pass that vehicle, closing on my vehicle. At that time is when I received the speed measurement.
Okay. Is there a reason why the sergeant didn't take action with the Kia?
Because Mr. Hicks passed the Kia, making him the fastest traffic on the roadway.
Okay. Did you see him pass the Kia and then slow down and go behind the Kia?
I saw him pass the Kia. I don't remember his positioning afterwards.
Okay.
So I never clearly passed.
Okay, 1 second.
Okay, sorry.
Okay.
Go ahead. I'm sorry.
Okay. Anything further, Sergeant James?
No, ma'am.
Okay. Mr. Hicks, now I'd like to hear from you.
I never completely passed the Kia. When I got over to merged over to the middle lane, I sped up just a little bit. I didn't pass the Kia, and then I realized that Sergeant James started slowing down. He didn't hit the brakes, but it was noticeable that he was slowing down. So I slowed down and jumped right back behind the Kia because I didn't want that interaction. I had license, insurance, and everything. I just didn't want the interaction, so I jumped back behind the Kia. But to say that I passed the Kia and to go 95 is just outrageous. Like I said, I don't know if motorcycles are a trigger for him. I don't know what he was going through that day. But there was no intention to break any laws that day, especially because I'm a huge advocate for other bikers.
Okay.
Especially for pulling over for officers and everything. That's not me.
Sergeant, do you have a trigger with motorcycles? Yeah, Sergeant. Do you have a thing where you are offended by them or?
No, ma'am. I have a cycle endorsement myself.
Okay. I'm going to find you responsible for the ticket, but I'm going to have somewhat sympathy for the court. I'm going to find you responsible for limited access 16 to 20, and that's $200. How long do you need to pay?
May I ask oh my God.
Okay, let me just say something. I'm just going to tell you something based upon what I heard. I would, if I was being very strict and had no heartstrings that you could pull on, I would find you responsible for the ticket as written. I'm exercising very little discretion that I have, and I'm removing the construction zone endorsement, and I'm lowering the points because, as I said, you were looking at over 355, 31 to 35. Like my construction zone on my scale only goes to 326 to 30, which means this is more. Okay, so I'm now changing it from $355 in a construction zone and 5 points to limited access 16 to 20 over, which is $200 and 3 points, which you should get it.
I get it. It just hurts me regardless because I'm in trucking school also. So
Okay.
the ticket this just hurts me bad.
I know. That's why, I was trying to put you in a different line, but you wanted to have the hearing. And so I'm trying. Listen, what I'm trying to do. I tried to give you what you want and had an informal hearing. If I was strict letter by the law, you would walk out of here with 5 points construction zone, more than 5 points. I don't even know what it is because I don't do the points as Secretary of State. I feel that your impassioned presentation and the communities in which you ride maybe got just the day got away from you. Okay. So I'd like to show you some courtesy, and I'm trying to show respect for law enforcement who was on the road and saw that. So I kind of just balanced.
And I do respect law enforcement. I want to say that I do respect law enforcement. I just can't agree to 95 miles per hour.
I know you didn't, and that's why I gave you a ruling. You didn't agree. We had a hearing, and I've given you the ruling. So how long do you need to pay?
I can pay immediately.
Okay. Let me look. Limited access. How many? There's no driver school for that, is there, Sergeant? Is there something?
For what, ma'am?
If I say limited access 16 to 20, that's $200 and 3 points. If I did limited access 11 to 15, is there some kind of program with the state that he would qualify for?
That'd be based off of Mr. Hicks's previous driving record.
Oh, I don't know it. I don't know. I didn't look at it. Okay,
I don't have access to that currently.
I don't have it either. So now here's one thing, sir. You can file an appeal if you're unhappy with the ruling and have a new hearing before the trial court. As the sergeant can, he can also file for a hearing. Okay. So the court will give you 7 days to pay. All right.
Okay.
All right. And if you're dissatisfied and you want to have a new hearing, either one of you, you may file an appeal and have a hearing with the trial court.
Thank you.
Thank you. Good luck to both. Oh, no, I have another case here for Sergeant James.
Next matter before the court is Selena Wergow and Jason Lambert. That's file 12-14709-DC. I do see Mr. Lambert is here. Do we have Ms. Wergow with us?
We do not, Your Honor.
All right. I believe this is a objection to referee's recommended order filed by Mr. Lambert. Mr. Lambert, you want to tell me what it is that you object to and why?
Well, it's like a 600% increase right off the bat, but also the biggest thing is it was filed a few years ago. We switched over to Florida, so I was making payments in Florida, but because of the arrearage, she filed with the state attorney general, and I'm still on probation trying to get that paid off. An increase to $1,600 a month, and in fact, it said it went back to March, so I owed like another $4,000 to get that paid off by the end of this month. That jumped up to $8,000. She did say we were supposed to have that referee hearing back in February, I believe it was. And when we went to that, she was present with that, and she was in agreement to have a conversation about a lesser amount. But the referee at that time said that he didn't have time to hear us, and he said if I want to object to it, then I have to file again, which is what I'm doing now. So, I've got the paperwork here in front of me with the calculations, and looking at the end of the day, you know, with what they're wanting me to give and what, I mean, that puts her monthly adjusted income at $1,000 over mine. So, you know, I mean, I've been doing what I can in the last few years to make more and more money to get this all covered, because I had 3 years to pay off, you know, 20-something $1,000, which that's a different story. But, you know, but every time I make more now I got to get hit with it. So I, you know, but the more I make, the farther behind I get on it.
All right, Mr. Lambert, simply saying that you disagree with the number doesn't give me a legal basis for determining that the number is wrong. What information or what documentation do you have that shows that the numbers used by the friend of the court were inaccurate or were wrong?
I guess I can't say that they're inaccurate or wrong, but if at the end of the day, you know, it puts my income at $1,000 a month less than hers, I mean, that seems like there's a miscalculation somewhere. I mean, I don't know. I don't do the calculations. I don't know how it's done. But like I said, I mean, you know, she was in agreement to having a conversation about it, and we weren't able to during the mediation, which is why we're here again today.
Well, the referee is not a mediator. That's not his job, and it's not his position to mediate and to determine whether or not the parties reach an agreement. And even if the parties reach an agreement, typically that's not a reason necessarily for changing the child support guidelines in the formula. So if you guys had an agreement, we could have looked at it and said, does that meet the guidelines, or is there a reason to depart from the guidelines? But you guys didn't reach it. So the referee is not required to conduct a mediation. So
under the guideline, I'm sorry.
Go ahead.
I was going to say, under the guidelines of the state order with the probation, I'm not allowed to have contact with her. So like, I'm not allowed, I can't reach out to her and have a conversation.
I can't help that. I can't change that. So all I can tell you is the referee's not required to do what you're asking, which was mediate, which is give you a chance to negotiate with each other in court. That's not what he's there for. That's not the process. So having no mediation ability, unless the parties are able to, and it sounds like you can't for other reasons. The only other question before me is any of the information that the friend of the court used to arrive at these numbers, was it an inaccurate number or was it inappropriately used? And so far I've not heard anything other than you dislike the way it turned out. And I get that all the time. So I understand what you're saying, but I can't change that process unless there's an inaccurate number. The guidelines.
Sorry.
Let me just finish for just a second. The guidelines for the state of Michigan have been established by federal rule and by state rule. And it's gone through a vetting process, and the courts are told that we're required to use the process, that the guidelines, the computer program for that, unless there is a legitimate reason to depart from it, a legal reason to depart, not just I disagree with this increase or that sort of thing. So I've got to have a legitimate error, or I've got to have a reason to depart from what the law says I'm supposed to follow. So do you have any of those reasons?
I mean, I don't know. I can't say that the calculation, I just think a 600% increase overnight, I mean, that's catastrophic. I just signed a new lease. I can't afford my bills at that. That leaves me under $4,000 a month to make my rent and my payments and provide for my house. It seems absurd to me that, you know, because I finally got to where I can make these payments and get this probation paid off, that now I'm going to get sent back. I mean, I'm you know, they gave me 3 felony counts. If I get it paid off, it's a misdemeanor count. I've got no avenue to pay that off. That's $1,600 a month. It just seems absurd. I mean, you know, just to make the adjustment while I'm still under the state probation and all that. But, you know, that's supposed to.
I understand exactly what you're telling me, Mr. Lambert. I believe me, I do. But I don't see any legal basis for departing from what the guidelines requirements are, simply because it creates a hardship for one party or the other. The numbers of the income levels look appropriate to me that were used. I'm looking at the referee's the friend of the court's recommended dollar amounts. The deductions appear to be appropriate. They've given the proper net income. They've laid out all of the dollar amounts for the base support calculation, the healthcare allocations, ordinary medical, childcare expenses. All of that appears to be exactly the way that the program is designed to run. And that's why they do it that way. They lay it all out in detail. In case anybody has an objection, they can say, this is what we put down for this number. This is what we put down for that number. And as long as those dollar amounts are fed into the computer system correctly, I'm supposed to use what comes out of the computer system because that's been vetted by the federal government and the state government as to that's how we want to run our child support system. Any other information that you want me to know?
No, I just, like I said, just looking at the calculation, I mean, that drops my monthly net down to 3209 and hers up to 4266. How do I live on 3209? I mean, this is the first time in my life that I've made enough to cover this child support, which, you know, I've fought with this for years. And every time I've been told you need to make more money. Now I make more money and I might as well go back to what I was doing a year ago. At the end of the day, I had more money in my pocket. I'm making $50 an hour now, minus $12 an hour in taxes and stuff, and taking now another $10, $11 an hour to give over to her. It leaves me nothing here. I've got the same requirements here. You know, I just, it's just the calculations. I don't know. I guess, I mean, if that's what it is, then that's what it is. But I just, I mean, why, I don't understand why the system is designed to just keep kicking me down.
It leaves you 38 grand after your child support is what it leaves you. Are you telling me you can't survive on that? 38 grand a year?
Well, I mean, rent is 24,000 a year. I've got two kids. I've got 11-year-old twins here.
Why are you paying $2,000 a month for your rent?
Because that's what it costs.
Where you live?
Punta Gorda, Florida. Been here for 11 years.
There has got to be a cheaper place to live than that.
If I would like to move into a trailer house in Arcadia, but Selena doesn't live in a trailer house out in Vanderbilt. So I mean, it's just, that's not a fair assessment. I'm paying less now in rent than I was 3 years ago.
You're the one who chose to live in Punta Gorda. I can't change. You're asking me to change numbers based on your decision about where to live and what to spend your money on.
How much is rent in Gaylord, Michigan?
I live in a 3,000 square foot house and I pay $1,200 a month to the bank for my mortgage.
That's a mortgage, sir. I can't get a mortgage because I have X amount in child support and my income's not there.
I'm just telling you, I live in a very nice house in a very nice subdivision because I chose to live in Gaylord, Michigan.
That's a mortgage, sir. That's rent.
You have the right to live wherever you want to live, but you made that choice. Nobody else did. So I'm not going to change child support because you decided to live in an expensive area.
Or, I mean, yeah, I don't, I guess, I mean, I paid rent in Gaylord in 1998. It was $1,200. That was 20 years ago. I would assume it's gone up since then.
All I'm saying to you is you got 38 grand, spend it how you want, but you got 38 grand to live on. There's lots of families in the world that live on less.
And now she's got 60. So that's great.
Mr. Lambert, I get it that you don't like it, but I can't fix it just simply because you don't like it.
I'm trying to get state probation paid off and I'm getting kicked. Like can't even wait till the end of that. I don't understand this. It's absolutely absurd.
It's ongoing child support. Your children don't have less bills because you have more bills.
So she's got a 600% increase since this time last year?
She doesn't get any of it. She gets to pay the kids' bills. That's what it's for. It's not for her. It's for the kids. If you don't like that, that's too bad. That's the way the world works. You bring kids into the world, you pay for them.
Okay. Yes, I do. And I don't get to see them. And
then file a motion to see your kids for more parenting time. Nobody's stopping you from doing that.
Luann Dean. Fought her for years.
Your objection is denied. Thank you very much, sir. That's all for today.
Yeah, of course it is. Bye.
Have a good day.
You call the Ingersoll case next.
Yep.
I will let them be.
Next matter is Nigel Ingersoll and Cassandra Ingersoll. We also have a companion case of Nigel Ingersoll and Krista Carnahan. The Nigel and Cassandra case is 23-19438-DM. The Nigel and Krista case is 15-15991-DM. I do see Nigel is with us. Krista is with us. I do not see Cassandra yet. Is she on?
She is on.
All right.
I've asked her to start her video.
These are Mr. Ingersoll's objections to the child support recommendations in both of these files. Mr. Ingersoll, what is it that you are objecting to and why?
Your Honor, I am objecting to the support amount because I think it's a little steep. Now, I filed that motion a little ways back. We just had court the other day, and at the time of me filing the motion, I had not gotten to see my son, and I had definitely disagreed with having to pay her if she was just holding him hostage. Now that there's an order and there's some parenting time established, I think I'd rather just have a couple questions instead of an objection.
All right.
The first question, if I may proceed, Your Honor.
Go ahead.
So I just want to know that if I make the child support payment that's recommended, do the mothers of my children get that in full, or is the state somewhere somehow going to find a clever way to try to dip their hands in what should go to my kids when there's not a vested financial interest from the state of Michigan on either case? Neither one is out of state and not drawing assistance, and the other one is also not drawing assistance. So if there's no state help, I just want to make sure that the state's going to stay in its lane and pay these women the money that my children deserve instead of funneling it into their pockets for pressing a couple buttons.
As far as I know, Mr. Ingersoll, the money that you pay for child support goes to the children for child support.
All right. All right. That's all I got. Actually, I do have one more question. So I am expecting another child soon, and I was wondering what the time window is for me to have this re-looked at again. I know that with another child, it should be split a little. While I do not disagree that I should have to pay some support, I just want to make sure that I can make my ends meet and fulfill my obligation, because fresh out of, vacation land, I'm really just kind of getting on my feet again, and I'm really starting to, reestablish myself in a relationship with my children, and I just don't want to drop the ball and fumble your recommendation and end up in jail with no license. And
The answer to your question is, once the new child has been born, if you would take a copy of the birth certificate to the friend of the court, they can then conduct a review of the child support and give you credit for another child in your household, and see if that changes to any degree the child support that is owed to the other children that you already have. The friend of the court is, they do that kind of review on a regular basis, and I'm sure that they would be happy to do that again in this case once the child has been born.
all right, and then I guess one more question, and I'll let you get going. Is there going to be a retroactive, like some surprise number that's going to throw me right out of my Jordans? I don't know how this whole thing works. I was gone for a little while, and there's been a recommendation, but it hasn't been established. I'm just wondering if you guys are going to throw a surprise $5,000-$10,000 fee at me, like, oh, by the way, you also owe this, or if we can start fresh so I don't end up in the hole.
Okay. Mr. Ingersoll, there is on each of the recommendations an effective date. It's on the first page of each of the recommendations. It indicates the effective date in one, which is the one involving Krista. The effective date of this recommendation is December the 1st of 2025. And the one involving Cassandra is August 22nd of 2025. I'm assuming that's when the request was made for each of those reviews to be made. So those would be effective as of those dates, so that they would go back to those dates and begin the calculation then. So there's always, because we have to start a process and then work it through, there's always a little bit of time where that does accrue, quote, an arrearage. But nothing is done as far as enforcement goes as to that arrearage, as long as you're making your payments on a regular basis. So there's no adverse action against you, and that's that arrearage is repaid over time as you go on and continue to make your payments. Does that answer your question?
It does. The only thing I am confused about is, so you said the case with my daughter is backdated to the day I got out of prison. Like, I wasn't working. I was at home with the kid. Like, I didn't start working until a few months after I got out. You're really holding me accountable?
It starts when you get out. Not the kids' bills don't go away simply because you haven't got a job yet. They still have bills. So it goes from the date that you're out, or the date that the other party asks for it. Ms. Cassandra, I'll get to your question in just a minute. Any other questions that you have, Mr. Ingersoll?
Yeah, what about the times that I wasn't allowed, where both of these women filed PPOs on me and I wasn't allowed to see my children? Like, you really don't think that's kidnapping, hostage? Like, since they decided they wanted to take that route, I don't think I should have to eat that payment when I wasn't getting to see my children against
Mr.
my will.
I apologize for interrupting. There is not a direct correlation between there's no pay to see your kids. That's not how this works. You pay because the kids have you pay because the kids have bills. If you believe that your parenting time has been violated, you have the right to take that issue, parenting time, to the friend of the court and ask for makeup parenting time if you believe that there's been a problem with it. But there is no direct correlation between I didn't get my parenting time, so therefore I don't have to make my child support payments. That is not a legal right. Any other questions that you have, Mr. Ingersoll?
Yeah, what's the total I owe you guys? Like, should I call?
You'll have to talk to your caseworker about that. I don't have access to that information in front of me right now.
All right. Okay, I'm done.
All right. Cassandra, did you have a question for me?
Oh, can you hear me?
I can.
Okay, cool. So I'm just curious, since all of this has gone down, I've lived in Tennessee now for just over a year and a half, and in that year and a half, $1,000 in childcare, like daycare expenses in that year and a half, and I have proof of all of that. Is there a way I can try to get him to help me pay some of that? Like, I paid $200 a week for my daughter to go to daycare, and I've paid $200 a week for a very long time, and it's a lot of money.
You can file a request with the friend of the court to have that addressed or added to child support. I'm not telling you whether or not it's going to be granted, but you have the right to request that. Ms. Kraus has the file, both of these files. So if you would talk to her and see what documentation that she would require in order to move forward with determining whether that would be allowed. And then you can, if she doesn't allow it, you can object to that, or Mr. Ingersoll would have the right to object to it as well. And that would be determined at a hearing in front of me after Ms. Kraus has a chance to see everything and make a recommendation. Ms. Kraus, is there anything else that you would ask about for that particular request?
She would just need to, because she is in another state, she would just need to submit that information indicating that she would like a review. That should be under a change in circumstances. The only thing it wouldn't do based on a review option is retroactive to the date. So her other option would be filing a motion to have the court address that date.
All right, so Ms. Ingersoll, basically what all that means is get the paperwork from Ms. Kraus, submit what you want, talk with her about what can and can't be done. And then if you disagree with that, we'll have a hearing on it, just like if Mr. Ingersoll disagrees, we would have a hearing on it, okay?
Yes, sir. Understood. Thank you.
All right, that's all for today then. Thank you all very much.
Thank you.
The objection in both files will be denied for the reasons stated on the record. All right, the next matter is Nicole Brandenburg and Tyler Goff, or Nicole Brandenburg and Tyler Goff, file 09-13272-DS. We have Nicole Brandenburg or Tyler Goff with us.
Neither party is present.
Your
Ms.
Honor, I
Krause,
do
if you-
believe that Mr. Goff is in the Otsego County Jail.
All right. Do you want to just pass this to next month, or what would you prefer to do?
Well, at the arraignment hearing that was on March 27th, his bond was reduced from $5,300 to $300, and he could be paid upon release. I did speak to Larry Brown yesterday. He indicated he was going to reach out to him. He wasn't aware that he was still in the jail, I guess. So I do not know. His balance is $21,000 as of right now, and current charging at $324 a month.
All right, we'll call the jail, see if we can get him on. While we're doing that, we'll take another matter, and I'll pass that and we'll come back to it. Court will call the matter of Nicole Brandenburg and Tyler Goff, file 09-13272-DS. You are Tyler Goff?
Yes, Your Honor.
All right, you're here today on a friend of the court matter. Ms. Kraus, can you update me on this case, please?
Yes, this hearing was adjourned from March 27th. There was an arraignment hearing. The defendant's bond was reduced from $5,300 to $300. Once that was paid, he would be released with conditions. I assume he's not made that payment as he's still listed and housed at the jail.
All right, Mr. Goff, what's your status at the jail? Why are you still there?
Just haven't paid the bond that was on there. So I just didn't really want to, because I'm barely working right now, very little. And if I were to pay that, that's literally about what I have right now. So what I'd be able to put on it after that for the month would be, $50 or $25 or something.
What is it that you do for work?
So right now I'm just working for cash with my dad, and it's very little. It's, once or twice a month.
What do you do with the rest of your time?
Pretty much sit around. I mean, I don't really spend time with people.
What type of work do you do with your dad?
So it's anything with pole barns, garages, cement roofing, tile.
So construction work, basically?
Yeah.
It's now the middle of April and good weather is returning. Are you telling me that you can't catch on with some other crew on a more full-time basis?
Well, yeah, probably, or find some other job.
So why aren't you working at that?
Just, slow going kind of right now, slow going,
Well, there's no going because you're sitting in jail and not even trying.
Well, right.
I don't understand that. What's your plan? You gonna sit there for the rest of the summer?
No, not at all.
So what is your plan?
I wanted to get out as soon as possible because I was awaiting a paycheck when I got put in here from my dad. He's actually holding a paycheck for me. I mean, supposed to be holding a paycheck for me. He owed me a paycheck when I got put in here. Like I said, the paycheck is $250, maybe $300. So it would literally cover my bond. After that,
Right. So you got a way to get out. And then what's your plan when you get out?
work with him or find more work.
Mr. Goff, how long have you been out of high school?
16 years, 15 years.
Your answers and your actions remind me of a sophomore in high school. No real plan, just going to kind of float along with whatever happens that particular day, and do whatever you have to do to just barely survive and get by. Tell me I'm wrong.
I hear you. I hear you. No, I'm not saying you're wrong.
Time to grow up. You've got $21,000 in money that you owe on back child support. Do you understand that?
Yes, Your Honor. Yes, Your Honor.
You could buy a very, very nice vehicle for that amount of money. You could walk in and pay cash and buy almost any car on a used car lot right now for that amount of money. And you would drive that car for the next 10 years. And your actions right now are, nope, I don't want to do anything. I'm just going to sit in jail and hope something happens.
Well, to be quite honest, I thought I didn't really quite realize the bond was there, and they pointed it out to me afterwards. For some reason I didn't have paperwork yet. I didn't get paperwork on the matter. The COs brought me paperwork. I didn't even realize there was a bond there. They brought me paperwork, pointed out the bond. Then I knew a bond was there. They had me gave me the ability to write in front of the court. I mean, I can probably cover the bond. I can probably come up with the bond.
Ms. Krause, we had a hearing on this last month or a few weeks ago, right?
That is correct. The 27th, it was indicated that he had indicated he had a check. You had asked the amount. He said he could cover $300. That's the reason that the bond was set for that amount. And just so you're aware, Your Honor, a little bit of history on the case. Since prior to this arrest and him sitting there, he was arrested in August of 2025. He served 21 days. Friend of the court did a report to the court on September 10th that he completed his sentence and was released. And then the defendant paid $200 in November of 25, $100 in December, and $50 in January, and then $100 in February. Then he failed to appear because there was conditions again, and then the new bench warrant issued. So this has been an ongoing process for Mr. Goff.
Mr. Goff, what you just told me about not knowing about the bond doesn't make any sense to me at all. We had a specific hearing where I reduced your bond from cash of $5,300 down to a personal recognizance bond, a $300 bond, so that you could get out because you told me that's what you had to get out with. And then here we are 3 weeks or so later, and you're still sitting in jail because you don't want to do anything.
It's not that I don't want to do anything. You know, I thought maybe the fact that I had 3 consecutive months of payments on my child support and fines and costs would make some kind of difference also, but I guess not.
You had 3 consecutive months of steadily reducing amounts that didn't even come close to what you owed. You don't get participation medals. It's not good enough to just do a little bit. Dude, you're $21,000 behind. What don't you understand about that? That's not just a little bit. You haven't made $21,000 in a whole year, have you?
Probably not, but
which is really sad because that's minimum wage jobs will make you $21,000. You just don't want to go out and get a job. I'm not changing bond, Mr. Goff. You want to sit in jail? If you want to sit in jail, sit in jail. That's got to be the dumbest thing I've heard in a long time. But if that's what you want to do, be my guest. We're done. You'll still owe your money when you get out. Next case, you can go back to sit in your cell, Mr. Goff.
All right.
All right, Ms. Spillane, before you, I'm not sure if you're going to go off yet, but if would you talk to Ms. Kraus on the Tyler Goff matter and schedule him for another hearing next month? I didn't want that to get away from me.
Your Honor, I'm already working on that.
Awesome, I appreciate that. I just
Yeah,
thought of
I
it.
actually was adjourning it out 2 months with the same provisions prior, but I can adjourn it for 1 month.
Yeah, he'll probably just sit in jail, and that's not appropriate. But
okay.
I'd like to see him in 1 month if you don't mind.
Absolutely.
Thank you very much.
You're welcome.
Somebody has caught the judge's attention. And you know, ladies and gentlemen, friends out there, it's never a good idea to be catching the judge's attention, you know? Am I wrong about that? I forgot to get my little tool. My goodness. I've got to scroll and find the thing I'm looking for and read. There it is. Gotta select the right thing. Okay. Hey, while I'm over here looking at the other screen, thank you so very much, X25 and Charlene. Oh, it's so wonderful. The support contributions you gave to the channel tonight. Thank everybody out there in chat. God, it's been an amazing chat night. Lone Wolf Bot has been busy answering questions, having fun, talking to you all, and I've had a blast reading all of the comments going in chat. I haven't been able to talk. I've been clicking comments all night. It's been insane for me. It's just been insane. But I appreciate you all. Hey, and by the way, in case nobody told you, we do have a weekend schedule, and it is coming up tomorrow. We'll have an 11 a.m. live with the puppies. We got an 11 a.m. live. Get out of the way so you can see them. That's noon Eastern time. It's going to be a fun live show. It's going to be a solid 2 hours. Got a bunch of stuff from this week that I already got on the cutting room floor that we haven't been able to watch for one reason or another, and we're going to watch it tomorrow. We're going to watch it tomorrow. There's lots of tornadoes out there, guys. Be weather aware. Do my little weather thing. Make sure you go and check out Ryan Hall. Y'all, he's got all the latest weather information. And while we're at it, ladies and gentlemen, all you crazy cats out there, all you supporters, look at that. Oh my goodness, thank you all for being here tonight. It has been a wonderful, wonderful get together. Sit here and talk about these cases together in chat. I hope we can all do it again tomorrow, and the next day, and the next day, and the next day, because we do this every single day. We'll have premieres. We'll have premieres tomorrow night and Sunday night. at 8 p.m. That's our normal weekday night get together. Then we'll be doing the same type of court get together every night of the week next week. I am your lone wolf Boozle. This is what I do. I watch court for you. I get the stuff together. We all watch it together. What can I say? I've been doing early morning releases at 4 a.m. every single day, where it's just kind of an independent video drop. You'll be seeing more of those. Every single day we got a noon video that goes out. This is my time, 4 a.m. Central Time, noon Central Time. So if you guys are so inclined and you want to see more, I'm here. We've always got more videos. See you next time. Tomorrow, in about 12 or 13 hours. Be safe, guys. It's crazy out there. No, I'm not gonna do it. I'm not doing the Ferris Bueller day off. I wonder what happens if I click the credits. This is the credits that have happened since the last time I clicked the credits. Anything? People, look at this. These are all the people who have been talking while I've been talking and saying, good night, ladies and gentlemen. Good night, good night, good night. So if you would be so kind and allow me to say thank you all so very much. It's been a blast. Wow. It's an interesting speed, huh? Life moves pretty fast if you don't stop and look around once in a while. You could really miss it. Good night, ladies and gentlemen.